morning. We'll be moving to our next talk now on costs. I'm Benjamin Gray, and next to me is Daniel Tatton Brown, KC. I'm going to be talking about recent legal developments in costs in employment tribunal litigation in the last 2 years or so, and then Dan will be focusing on the practical side of litigating costs points in tribunal cases. The structure of my talk is going to be under these headings, which are also in the handout. Starting with the rules, the Employment Tribunal rules have changed, but it is all the same notes, just in a different order. So if you are making applications or dealing with costs matters, you just need to make sure that the rule references are in the right place. And you will see in the second point on this slide that the Tribunal's Procedure Committee is consulting until the end of next month on the topics on this slide. The power, however, to award interests on costs, which is being consulted on for other tribunals, is outside of the TPC's authority, so there may be further developments in this area. The first main area of development, which unfortunately is a little bit garbled on the slide, hopefully it's all right in the handout, is on what amounts to the conduct of proceedings. Gold Panda looked at what was the conduct of proceedings rather than what was the conduct. This was a case where two companies tried a novel and innovative legal strategy of trying to get themselves removed from the register of companies in various ways after the litigation started to avoid paying out. On appeal, they perhaps a bit more realistically accepted that this was unreasonable behaviour. But what they said to the EAT was that this was not conduct of proceedings. The EAT thought otherwise. They held that it was legitimate for an employment tribunal to examine as part of the whole circumstances the likely effect of the conduct and the subjective intention behind it. Any conduct by a respondent intended to influence the course or outcome of such proceedings by making continuance of them impossible for a claimant certainly could amount to conduct of proceedings. And here, as the intention of the appellants was to bring the proceedings to an end by frustrating the claimant's ability to establish liability on the merits of their complaints, it was therefore part of the way the respondents resisted the case, and the Employment Tribunal was entitled to view it as the conduct of proceedings. Moving to the earlier part of the test, what is unreasonable conduct? Well, Leaks, which is unfortunately one of the garbled lines, showed that a refusal to engage in judicial mediation could amount to unreasonable conduct, but it would depend on the facts of the case. And then in Dowding and the character group, the tribunal dealt with a point that tends to come up in costs litigation. It is not uncommon that when a party holds out for an unrealistically high amount of money in resolution of an ET case, they reject what would be otherwise a very sensible offer to settle. And what a party might sometimes do, relying on authority, is say, well, I wasn't unreasonable because this case was never really about money. I wanted a declaration or a recommendation. And if that is true, then it can be a defence to a costs application. But what Dowding shows is that that has to be the actual reason for the party's conduct. It is not something that you as the lawyer can come in and say, well, in the abstract he could have done it this way. It has to be the real reason that they conducted the case in that manner. So the practical impact of all this is that if you are rejecting or refusing to engage in an offer or process of settlement, you should be looking to set out your client's rationale, at least in brief, or for example at a case management agenda if you're not going to mediate. And if you are on the other side and receiving something saying, it's not really about money, but I will settle for £2 billion, it might be worth setting out a little bit in response to try and call their bluff on it. So the next slide we have, it's Dan's day with technology, is what we can do as an alternative to making a costs application. Because, of course, during the life of the case, the conduct that could ground a costs application can also support other applications or remedies in an employment tribunal. The first is striking out, and we'll all be familiar with the ability to do that on the merits, so I won't bore you with telling you what you already know. But in terms of conduct, there have been several cases in the EAT, and I think it's been my experience in the past few years at first instance as well, that there is an increasing emphasis on the fairness of proceedings, the proportionality of resources that a party can be expected to spend putting up with unreasonable conduct of proceedings. And what is clear from the authorities on the slides is that the appropriateness of striking out a case can include an assessment of the proportionality and fairness of the costs incurred due to a party's unreasonable behaviour. And so if you are faced with someone who is driving up the cost or complexity of conduct, a particularly live risk with the ability of ChatGPT to generate reams and reams of turgid correspondence, it is worth reading these cases in full. It may well be that striking out is justified. If so, you should be clear with the Employment Tribunal how those costs have been run up. You should be providing a schedule of costs, and you should be identifying clearly what the impact of the other side's behaviour is. And that can be a particularly powerful point if a party says, well, if you made any costs order against me, I couldn't pay it. Because then, of course, any unfairness of the trial includes irrecoverable costs. We then have aggravated damages. This is again popping up more and more in the ChatGPT era, which seems to love including it on schedules of loss, even without any justifiable legal basis. But it does have its time and place. It is a subset of injury to feelings in cases where that can be awarded. And in the right case, it might be a better tool to use, especially if you cannot point to how the unreasonable conduct pushed up the financial costs of litigation. The next slide is designed to inspire despair. I'm aiming for it to be the most depressing slide of the extravaganza, so we get it out this morning. The point that is being raised more seriously in Huntley is that there was an argument that if you want to justify a costs award on the basis that the claim had no reasonable prospects of success, it had to have no reasonable prospects of success from the point of commencement. The EAT disagreed. You can start a case reasonably enough. You can have a reasonable belief in its prospects, but it can over time become clear that it is hopeless. For example, once you have seen what the other side's explanation or evidence is in their ET3 or disclosure. If you still press on, regardless of that, then you may well be on the receiving end of a costs order. It is therefore important for us as professional advisors to make clear to our clients and to actually keep the merits of a case under review on a continuing advisory basis. And if you are going to apply for costs, it is therefore particularly important that you think about when you say the case actually became hopeless and make sure that your costs application is pitched at that level. And in particular, that the schedule of costs you provide clearly delineates the point or points and therefore the costs attributable to the point of no return. What you will often hear when you are making a costs application, or indeed if you are advising your clients that the case isn't quite as brilliant as they thought it is and they might be on the receiving end of one of these applications, is the somewhat complacent response that, well, that's not really a risk because if it was, you would have applied to strike out my case. Now, the overall point is that that can be relevant, but it is not decisive. And there has been quite a bit of appellate activity in this area, and there is perhaps some tension in the authorities. In Madhu, the EAT suggested that as the test for striking out and the test for costs are similar, the principles in discrimination claims in Anyanwu can apply just as they do on striking out. Now that point is likely to get airtime from claimants, and there is a risk that it is going to go further than it should. First, Madhu is about a very particular type of case, recruitment discrimination. That is one where claimants cannot so easily make an assessment of prospects because they do not know any of the people involved, and the case will depend on whether someone usually unknown to them is telling the truth in the explanation that they give. That logic does not hold for many employment discrimination cases where the employee or decision maker can or should know better. Second, there's an obvious difference between a tribunal approaching strikeout and a party approaching litigation. the tribunal approaches it cold. It does not know the context and therefore cannot make any realistic assessment in Anyanwu-style cases on witness credibility because it doesn't know who they are, it doesn't know who the employer is. Third, the reasons more widely why a tribunal might struggle to assess prospects at a preliminary stage are sometimes quite separate to whether a party is acting reasonably. The most obvious one being that a tribunal might reasonably say, I can't strike this out, there is a clear dispute of fact between the witnesses. But that might be because one of the witnesses is lying. And if so, strikeout wouldn't be justified, costs would. And you will see in the other authorities on this slide that the principle that is floated in Madhu is put into quite careful constraints. Radia and Carroll Cliff both note that these are different tests. In particular, strikeout takes a case usually at its highest, and costs as a more holistic assessment. And Huntley makes the important point that the reasons why a party might not apply to strikeout could be quite different to whether or not costs is justified. So the takeaway then is that Madhu should be treated with caution, and if you are giving a costs warning, it might be sensible to set out in a few short lines why you haven't applied to strike out the case. The basis of assessment, costs can be awarded on the standard or indemnity basis in the Employment Tribunal, but the indemnity basis for ET litigation is higher than it is for civil litigation. That is because it has to be something out of the norm and therefore out of the norm from what would ordinarily justify costs in the ET. You will have to identify, if you are an applicant, something that takes it a little bit further than just being unreasonable or pursuing a hopeless case. Finally, ability to pay. Often a paying party will say, well, I can't afford to pay this. After all, you sacked me. I haven't got any income. That's not a complete answer. If there is some other source of funds, it is open to the tribunal to look at that. In Eke, the claimant's spouse had a significant amount of personal income and disposable income. And in Amuba, a campaign organisation backing the litigation and making grandiose statements about fundraising was taken into account on whether a costs order should be granted. But you have to be careful to make sure that you are applying the words of the rules. Sometimes we say it's means, sometimes we talk about income. It is ability to pay. And simply showing the existence of another pool of funds is not enough. You have to show that the existence of that other income stream, asset, or benefactor illustrates that that person has the ability to pay. It cannot be assumed. And so in Eke, whilst it was relevant for the tribunal to take into account the fact that the claimant's spouse had another source of income for the family, it got remitted down on appeal because the tribunal had to go on and consider how that fact impacted the claimant's own ability to meet a costs award. So that's it from me, and I'll hand over to Dan.
Hello everyone, thank you Ben for that erudite review of recent case. So I'm going to, at the risk of lowering the tone, focus on some practical considerations arising in the context of Employment Tribunal cost applications. The legal framework is provided by Rule 74. You will be familiar with it. The essential point is that the relevant gateway condition to a tribunal making a costs order is it being persuaded that a party has acted unreasonably in bringing the claim or part of the claim, or, as Ben indicated, persisting with the claim beyond a particular point in time. I'm going to focus specifically on cases involving multiple allegations of discrimination and or whistleblowing detriment. These are the largest cases and most expensive cases as a generalization. They are also the cases, again as a generalization, which often give rise to the suspicion on the part of respondents that allegations have been advanced either to overcome the statutory cap on compensation for unfair dismissal, conventional unfair dismissal, and or to enhance the embarrassment or nuisance value of the claim. And it's those sorts of considerations that often encourage respondents to think they might have a prospect of getting a costs order against the claimant. Can I start with a psychological observation? The reason or reasons why claimants bring tribunal claims are no doubt numerous and varied, but most claimants at some point will carry out some sort of cost-benefit analysis, and they will assess the potential upsides of bringing a claim against the costs, and those costs will most obviously be the legal costs, the actual financial costs, opportunity costs, there may be emotional costs, there may be reputational costs. But typically the claimant will proceed in that analysis on the assumption that even if the case goes pear-shaped, they won't be on the hook for their opponent's costs. And I think a key strategic objective, if you're acting for a respondent, is to, if you can, and obviously each case is fact-specific, plant seeds of doubt in the claimant's mind as to the validity of that assumption. In other words, at the very least, you want to be ensuring that the claimant is having a discussion with his or her advisors about the possibility of an adverse costs order and the likelihood of such an order being made in their case. And the more credible you can make that possibility, the more likely it is that the claimant will lose enthusiasm for the litigation, the more likely it is that you will be able to secure an early or advantageous settlement. And that may be a gain that's achieved even if you never ultimately make a costs application or indeed secure an order in your favour. I think it's important to understand the legal framework, and if you're acting for respondent, it's not very encouraging. The essential reason why that is the case was explained quite clearly, in my view, by His Honour Judge Burke in a case called Sacker, which is now quite an old EAT authority. And what the judge said was set out in the slides. Very rarely is there overt evidence of discrimination, and thus it may be and often is very difficult for the claimant to know whether or not he has real prospects of success until the explanation of the employer's conduct has been heard, seen and tested. In other words, at the conclusion of cross-examination. Nothing we say should be taken to impinge on that important principle. It follows that a costs order against an applicant in a discrimination claim is always likely, in the absence of misconduct, to be made only in very rare and even an exceptional case. So that seems to be a pretty watertight defence on the part of the claimant to a prospective costs application. The claimant will be able to say, well, I didn't know whether the employer's benign explanation for the impugned conduct would be vindicated at trial until all the evidence had been heard and tested in cross-examination. So even though I ultimately lost, it can't be said it was unreasonable for me to have proceeded down this path. So I'm going to make 4 brief points as to how one might try and meet that difficult scenario. The first is contemporaneous documentation. We all are familiar with the Guestmin guidelines. We all know the importance of contemporaneous documentation to fact-finding. If you are lucky enough to be involved in a case where there is credible contemporaneous documentation which indicates why the impugned conduct took place, it may be WhatsApp messages, it may be text messages, it may be emails, and that explanation for the conduct is non-discriminatory and not linked to alleged whistleblowing and so forth, then for goodness sake exploit that advantage and put pressure on the claimant. I'll give an example of what I mean. I did a case a few years ago now where I was for a respondent. The claimant was a senior lawyer employed by a hedge fund. She was kicked out somewhat unceremoniously. She alleged it was because she was a woman and or because she had blown the whistle. The respondent's case was that she was booted out because of increasing concerns about her erratic behaviour and performance. There were privileged documents in the form of attendance notes drafted by my instructing solicitor which indicated in the clearest terms the contemporaneous concerns that the employer had developed about the claimant's erratic performance and conduct, and that was the reason for dismissal. We disclosed on a without prejudice save as to cost basis those attendance notes. There was an interesting issue as whether that privilege was raised because it was on a without prejudice basis, but they were disclosed, and a low-ball offer to settle was made with the threat that if the claimant didn't withdraw her claims and accept that offer, that would be viewed by the respondent as unreasonable conduct. And it wasn't a complete answer to the claimant's case, because she was able to say, well, the perception of my poor performance was itself tainted by misogyny and so forth. But it was very credible, contemporaneous documentary evidence indicating what were the true reasons for the dismissal. And the case settled relatively quickly thereafter. And certainly, had I been advising the claimant, I would have been concerned at the prospect of fighting that case to trial, losing on the basis of that evidence, and then facing a costs order, cost application based on the premise that it was unreasonable for her not to see the validity of that evidence and act accordingly by withdrawing the case or accepting the offer. Point 2 is really the corollary of the Sacker principle. It's concerned with hindsight bias. If you bring your discrimination claim, you lose it, you face a cost application, almost inevitably you will say, well, of course we lost, but it wasn't unreasonable because what is clear now that the dust of battle has settled was not clear at the time that the parties took up arms initially. And it's quite a compelling point. I think to try and meet it, or one way to try and meet it if you're acting for respondent, is to set out, whether on a without prejudice or an open basis, in some granular detail, the conclusions that you say the tribunal are likely to reach and why you say they're likely to reach them, almost certainly based on contemporaneous documentation. And if, having done so as part of an offer to settle or an invitation to withdraw or whatever it might be, the case doesn't settle, and you ultimately win for reasons that mirror those set out in your letter, then you can answer that this isn't a case of hindsight bias because we, the respondent, predicted the outcome of the case when we wrote this letter, perhaps after disclosure had been completed. And it was unreasonable in those circumstances for the claimant to have pressed on with his or her claim. If you're acting for a claimant, responding to those sorts of letters is quite important. One of the problems in the Radia case in which I was involved was that Herbert Smith, on the part of the bank, Jeffries, wrote such a letter, and Mr. Radia, at a time I was happily not involved in the case, ignored it, and that was viewed as a facet of the unreasonable conduct of the proceedings. So if you receive such a letter, don't ignore it and explain why it is, as a claimant, you are pressing on with the case. And typically you will focus on areas of continuing uncertainty, the areas of disclosure that I've not yet seen. We don't accept X's explanation and we want to test it in cross-examination, whatever it might be. Point 3, this is my penultimate point. Can you establish that the claimant doesn't believe in his or her case themselves? In other words, is this a try-on? And the critical point to note is that to win on liability obviously doesn't require you to persuade the tribunal that the claimant doesn't believe in their own case. All you need to show is that the reasons they've advanced or have alleged for the impugned conduct are not correct. The relevant act wasn't tainted by discrimination or materially influenced by the protected disclosure. But if you can persuade the tribunal that the claimant themselves didn't really believe in their case, that this is all a monumental exercise in trying to elicit more advantageous settlement terms, exploiting the nuisance value of the claim, then your prospects of getting a costs order, and critically a significant costs order, dramatically increase. And of course, simply establishing that there's been unreasonable conduct of the proceedings is a gateway condition to getting a costs order. There's then a discretion to be exercised as to whether or not to make such an order, and if so, in what terms. In Radia, the essential reason that £600,000 plus costs order was made against him was the tribunal, I think entirely justifiably, concluded that Mr. Radia himself didn't believe in his case. And one of the reasons for that conclusion was that the allegations of disability discrimination that formed the claim first emerged in the context of discussions about a negotiated departure from the firm. I've been involved in one other substantial discrimination claim in which a substantial costs order was made, and again the underlying rationale for the costs order was the tribunal's finding, again I think justified, that the claimant's case was all a massive try-on. So consider whether that's a line of evidence you want to exploit at the liability hearing, even though it's not necessary in order to defeat the claim on liability. But a word of warning, you obviously need to choose your battles appropriately. If you go steaming in saying this is a hopeless case, we don't believe the claimant himself or herself even believes it, and you end up losing, then you have laid the ground for the claimant to make an application for aggravated damages, no doubt, but also more significantly, potentially financially, his or her own costs order on the basis that that dismissive attitude to this well-founded claim was itself unreasonable conduct. Final point before we break for coffee, it's to do with whistleblowing claims. And the point is simply this, that if a worker brings a whistleblowing claim, it is implicit in their assertion that they blew the whistle, that they had certain subjective beliefs that whatever it was that they claimed they said was in the public interest, beliefs that at the time they said it, the information they disclosed tended to show a breach of a relevant legal obligation. Those assertions don't depend on how the respondent's evidence pans out at trial, don't depend on subsequent disclosure. They are matters about which the claimant must know right from the get-go. And if the alleged whistleblowing protected disclosures are a clever lawyer invention, they're all a try-on, that's your suspicion, and you don't believe at the time that they were made that the claimant actually had those beliefs, it implies, if that's the conclusion of the tribunal at trial, that this was a claim advanced from the beginning on false and frankly dishonest evidence. And that is a basis, obviously, on which a costs order potentially encompassing the entirety of the claim could be made. And that was one of the grounds on which a costs order was made in the Dowding case, which is one of the ones that Ben's referred to. So if you're acting for a respondent in such a claim, and your strong suspicion is that this is a massive try-on, the claimant himself or herself did not credibly have the asserted subjective beliefs, that is a point you may want to seek to exploit in the context of making appropriate threats about potential future costs orders. That concludes our session on costs. We're now going to break for coffee. If any of you have questions for either of us, we'll be very happy to try to answer them over coffee. Thank you very much.